Hello, my name is David Nachman, and I'm one of the managing attorneys at the NPZ Law Group, NPZ Nachman Fulwani Zimochek Law Group, with offices in Ridgewood, New Jersey. We also have offices in Midtown Manhattan, and we also have an affiliated office in Canada and one in Mumbai, India, to better serve our clients. Today I want to talk about a question that we receive very, very frequently from individuals who are on H-1B non-immigrant visas. For those of you who are not familiar with the H-1B visa, the H-1B, of course, is the visa for professional and specialty occupation workers. These are individuals who are in the United States who have the equivalence of a U.S. baccalaureate degree and, of course, who are taking jobs with U.S. employers in their field of specialty. So these visas require that the individual who's taking up these positions has the equivalence of a U.S. baccalaureate degree. So one of the questions that we receive very, very frequently from individuals who are in H-1B is, if I am terminated from my H-1B position, is there a grace period? And the answer is no. It's generally recognized that there is not a grace period. If an individual is terminated from their H-1B non-immigrant visa, they are immediately deemed to be out of status. So what is the net practical effect, of course, of something like that happening? Well, if an individual is immediately out of status, and there are really two ways to look at this. One is you have to look at it from the employee's perspective, and two is you have to look at it from the employer's perspective. And we, as counsel for both employers and employees, often get those questions on both sides. So what I'd like to do first is to tackle the employer's side, or the employer's way to look at the termination of an H-1B and what the employer's obligations might be. So the first thing that an employer has to do is, if they terminate an H-1B, what the employer would want to do is, number one, probably have something like that in writing. It's very important to, of course, have the termination in writing so it's clear what the date is that that termination took place. The second thing that an employer is going to want to do is to immediately withdraw the H-1B, because if they don't withdraw the H-1B, what will happen is that the employer could potentially be liable for ongoing wage obligations if they don't withdraw that H-1B. Now, that's the legal aspect of it. There's also a practical aspect, and that is that a lot of employers want to work with foreign national employees because they understand what potential hardship they could thrust upon that foreign national if they immediately withdraw that H-1B. So that's a consideration which is sort of a gray area and something that you'd want to discuss with legal counsel if you're an employer, as to whether or not you want to leave that H-1B out there and how long do you want to leave it out there. It sort of becomes a question of how long a potential wage obligation you as the employer are willing to endure. The third thing that an employer needs to do with regard to an H-1B withdrawal is to also offer the employee, the H-1B employee, return transportation. And these are the types of things that the U.S. Department of Labor Wage and Hour Division, they're going to look at in the event that they go in and, let's say, for example, an employee files a complaint against an employer with regard to the wages. There's going to be an issue as to whether or not the individual was appropriately terminated, what that termination date was, because obviously there's going to be a calculation of the wages up to that termination date. And so oftentimes the Department of Labor will look at those elements to determine what the termination date is. Of course, another thing that the Department of Labor looks at in an audit, let's say a wage and hour audit, would be when a foreign national employee on an H-1B takes up new employment with a new firm. So that would sort of be utilized as possibly a cutoff date. Now, from the employee's perspective, what ends up happening is the employee, if they're terminated, there's no grace period. So what does an employee have to do? Well, of course, a foreign national employee in H-1B who may be let go by their employer needs to do a couple of things. Now, one of the things which we really like is that if we know that an individual is going to be let go, what we try to do in advance is to offer an opportunity to see whether we might be able to get a concurrent H-1B in place as soon as possible prior to the termination, because then what will happen is if they have concurrent H-1B's, if one of those H-1B's falls away, they still remain in status. So what you could possibly do is, let's say for example you have a heads up and you know a year in advance, and it's oftentimes not the case that you're going to know a year in advance, but let's say 4 weeks in advance. That's a little more realistic. Let's say you know 4 weeks in advance that an individual is going to be let go. Well, what you can do is you can file for a concurrent H-1B and maybe a part-time H-1B, pick up that second H-1B, and then when the individual gets let go, they're still in status. And then what they can do is stay in status that way, look for a new job. Maybe what they do is then they pick up the new job, and then they can let that concurrent H-1B go by the wayside when they've picked up a new H-1B. So that might be one particular strategy that they can do. Another one, which is very common, and we often do this for individuals, is that if they don't want to have a lapse, obviously, again, if they know that there's no grace period, and oftentimes we hear, oh, well, I thought that there was a 10-day grace period. Well, there's no grace period. The reason why people think there's a 10-day grace period is there's something in the regulations about 10 days, and so they read that to be like there's a grace period, but there's really not. And it's pretty clear from the enunciations of the USCIS that there is no grace period. But one of the other things that they can do is, if you know a week beforehand or 2 weeks beforehand that an H-1B is going to come to an end, the other thing you can do is you can file for a change of status. That change of status can be either to a visitor's visa, which allows an individual possibly to be in the United States up to, say, 6 months, during which time they can be looking for a new job, and then switch back to a new H-1B. So that's one way to preserve their H-1B status in the United States. So if an individual's status is in jeopardy by virtue of the possibility of a contract coming to an end or the possibility of a termination, we as immigration counselors can try to work with you and try to figure out what options you might have. And one of the other things we definitely want to do is take a look at your resume and try to figure out what other work visas you might be able to switch on to. So for example, file a change of status from an H to an O, or file a change of status from an H to an E. There's so many different types of options that are available. So the key here is for us to do a full spectrum of analysis for you to try to figure out what those options are, lay those options out for you, best to worst scenario, and then of course you make the decisions as to which one you want to pursue. So with that, I hope I've provided you with some good information about the H-1B termination and the grace period. If you have any questions at all, please feel free to give us a call. Your attorneys at the NPZ Law Group have lots of really good information and creative ways for us to be able to assist you to keep status in the United States should your H-1B be in jeopardy. Thanks very much for joining me today.